Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. I am, of course, attorney Andrew Branca for the Law of Self-Defense. And today we are here for a reading of the first substantive Second Amendment decision handed down from the U.S. Supreme Court way back in 1939, U.S. v. Miller. This is what we'll be reading through today. As promised in previous shows in which I read a law review article on the peculiar story of U.S. v. Miller. I'll link part 1 and part 2 of my reading of that law review article in the description of today's post. Provides a lot of historical context, makes clear that this entire decision was really a conspiracy by gun controllers at the time to have a test case that would allow the federal government to argue that regulation of firearms by the federal government did not infringe the Second Amendment, and thereby opening the door to much more regulation. At the time, they were considering primarily the National Firearms Act, which had just passed, but of course, the Gun Control Act of the 1960s and much more would be deemed constitutional on the rationale presented here. So, a little overview of this case. United States v. Miller, there were actually two defendants in this case, Jack Miller and Frank Layton. It's named after Jack Miller, but both men were involved. The decision was handed down in 1939. The facts of the case were that an Arkansas Federal District Court, that's a trial court, had charged Jack Miller and Frank Layton with violating the National Firearms Act of 1934, the NFA, when they transported a sawed-off, double-barreled 12-gauge shotgun in interstate commerce. Miller and Layton argued that the National Firearms Act violated their Second Amendment right to keep and bear arms. The trial court agreed with them and dismissed the case. Now, to be clear, the only reason the federal trial court agreed and dismissed the case was because the trial court wanted to create a test case to actually reverse what the trial court was saying. So this federal court judge was a gun controller. He was a New Dealer of Franklin Delano Roosevelt, fully supported the NFA. But there were questions. There was a lot of protests at the time that the NFA was unconstitutional. So this gun controller federal trial court judge pretended that he thought the NFA violated the Second Amendment solely to create a test case that could go to the U.S. Supreme Court and reverse his decision. So the question before the Supreme Court was, does the Second Amendment protect an individual's right to keep and bear a sawed-off double-barrel shotgun? In fact, I would argue that wasn't actually the real question. I would suggest the real question, because what the NFA did was it did not prohibit the right to keep and bear anything. What the National Firearms Act did was it created certain classes of weapons, short-barreled shotguns, short-barreled rifles, fully automatic machine guns, silencers or suppressors, and for those categories of firearms, it said you can buy them, you can own them, you can keep and bear them, but you have to pay a $200 tax every time it's transferred. And at the time, many of these firearms and suppressors themselves, their whole worth was not $200. So this was an egregiously high tax at the time. But the argument was, hey, we're not infringing the Second Amendment because we're not saying you can't have these things. You can keep and bear a machine gun. You just have to pay the tax. So this is a tax bill. That's all this is. So I would suggest the real question before the Supreme Court was, does the Second Amendment protect an individual's right to keep and bear a sawed-off double-barrel shotgun without having to pay the required tax under the NFA? And it was a unanimous Supreme Court decision. The Supreme Court did reverse the trial court, as the trial court intended all along, holding that the Second Amendment does not guarantee an individual right to keep and bear a sawed-off double-barrel shotgun. Again, I would suggest the real holding was it doesn't guarantee an individual right to keep and bear a sawed-off double-barrel shotgun without paying the tax. And writing for the unanimous court, Justice James Clark McReynolds, not the most famous of U.S. Supreme Court justices, he wrote the opinion, however, for the court, reasoned that because possessing a sawed-off double-barrel shotgun does not have a reasonable relationship to the preservation or efficiency of a well-regulated militia, the Second Amendment does not protect the possession of such an instrument. Actually, Justice McReynolds didn't say that it doesn't have a reasonable relationship to the preservation of a well-regulated militia. He said he didn't have any evidence in front of him in support of that position. Why didn't he have any evidence in front of him in support of that position? Because the appellants here, the defendants at trial, Jack Miller and Frank Layton, they never came to trial before the U.S. Supreme Court. Now, of course, they normally wouldn't come before the U.S. Supreme Court to argue a case, but their lawyer also never showed up. So our legal system is supposed to be an adversarial process, people arguing opposite sides of the question, and then the judges can make their decision based on those arguments. In U.S. v. Miller, the only arguments presented to the Supreme Court were the arguments of the federal government in support of the National Firearms Act, arguing that it did not violate the Second Amendment. There was no opposing argument. It would appear that the lawyer acting for Jack Miller and Frank Layton was also in on this conspiracy to create this test case and make sure it failed, that the NFA succeeded at the U.S. Supreme Court level. All right, with all that, again, for more detail on this whole conspiracy around creating a test case, look at my immediately prior shows on the peculiar story of U.S. v. Miller. It's a two-part show because the law review paper was quite long, but it provides a lot more detail on all of that. Today's show is sponsored by the Law of Self-Defense, specifically our advanced live online class taking place on April 20th, 2024. This is our full-day course on use of force law that makes you hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. We cover everything you need to know. Why and how the legal system prosecutes self-defense, the 5 elements of self-defense, the fundamental building blocks of any claim of self-defense. We cover defense of others and defense of property, consciousness of guilt, self-defense immunity. We spend almost an hour talking about interacting with the police in the aftermath of a use of force event, how to craft your own customized, legally sound self-defense strategy, and much, much more. Now, we only teach this class twice a year at most. So if you miss this April course, it'll be at least 6 months before you have the opportunity to take this course again and make yourself hard to convict. Do you know when you're going to be attacked? It's not up to you. The bad guy chooses the time, place, and manner of attack. You need to be ready for both the physical fight and the legal fight before that happens. And register now, and you can get up to 50% off for this April 20th Law of Self-Defense live online advanced course. Don't hesitate. Scan that QR code now, or simply visit lawofselfdefense.com/advanced. With that all out of the way, let's jump into the actual decision itself. It's not very long. United States v. Miller, 307 U.S. 174 is the site. From 1939 is when the decision was handed down. And you see here, Mr. Gordon Dean argued the cause, and Solicitor General Jackson, Assistant Attorney General McMahon, and Messrs. William Barron, Fred Stein, George Knapp, Marvin Smith, Clinton Barry were on brief for the United States. No appearance for the appellees. No appearance for Jack Miller and Frank Layton. No lawyer for them appeared to argue. No lawyer appeared to argue against the U.S. lawyers, the government lawyers. Mr. Justice Reynolds delivered the opinion of the court, and he writes, an indictment in the district or trial court of Western District, Arkansas, charged that Jack Miller and Frank Layton, quote, did unlawfully, knowingly, willfully, and feloniously transport in interstate commerce from the town of Claremore in the state of Oklahoma to the town of Siloam Springs in the state of Arkansas a certain firearm, to wit, a double-barrel 12-gauge Stevens shotgun having a barrel less than 18 inches in length, bearing identification number 76230. Said defendants at the time of so transporting said firearm in interstate commerce, as aforesaid, not having registered said firearm as required by the NFA, and not having in their possession a stamp affixed written order for such firearm as provided by the NFA and the regulations issued under authority of the said act of Congress known as the National Firearms Act, approved June 26, 1934, contrary to the form of the statute in such case made and provided and against the peace and dignity of the United States. Close quote. A duly interposed demurrer alleged the National Firearms Act is not a revenue measure, but an attempt to usurp police power reserved to the states and is therefore unconstitutional. Also, it offends the inhibition of the Second Amendment to the Constitution, that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, to translate this into plain English, Jack Miller and Frank Layton were arguing that the indictment against them under the NFA for this short-barreled shotgun should be thrown out because the NFA itself is unconstitutional. There was a lot of argument at the time. FDR and his New Deal were having trouble getting their policies through the U.S. Constitution. Much of what they wanted to do was unconstitutional. And so they would use tricks. Like instead of regulating something directly, they would instead put a tax on it and say, well, Congress has the power to tax under the U.S. Constitution. So we're not really regulating the thing. We're just taxing the thing, and that's allowed. And of course, that's exactly what the NFA did. Now, there was a similar law passed at the federal level about narcotics. Before this time, narcotics were lawful. Anybody could have narcotics. Lots of people, in fact, had narcotics at home perfectly lawfully. And it was a state police power to regulate narcotics and similar drugs, not a federal. There's nothing in the federal Constitution that says the federal government can regulate narcotics. So what did they do? They created a Narcotics Act that just taxed the narcotics into oblivion. So it made it a crime to have the narcotics if you didn't pay the tax. Exactly the same model as the National Firearms Act. And for many years, that kind of law was deemed unconstitutional. It was recognized as a ruse. You're calling it a tax, but it doesn't actually raise any revenue because all it does is eliminate the underlying conduct. So you are, in effect, regulating the underlying conduct. And for many years, the U.S. Supreme Court was saying these kinds of tax laws in sheep's clothing, we recognize what they are, and they're unconstitutional. Leading among those U.S. Supreme Court justices who recognized this was Justice McReynolds. For many years, he would find laws like the NFA unconstitutional, laws like the Narcotics Act unconstitutional. But as FDR continued to be president and as he appointed more Supreme Court justices, the percentage of justices who were in alignment with this approach, pretending it's a tax as a way of control, became the majority. And eventually, even Justice McReynolds gave up his opposition of these laws. It just became hopeless from a legal argument perspective. So one of these cases that reversed the trend, that made tax laws in sheep's clothing acceptable, was one we see referred to here, Sunzinski versus United States, involving that Harrison Narcotics Act, where we tax narcotics, and the Supreme Court said it was okay to do that. So if that was allowed for narcotics, then it's inevitable that the NFA tax law in sheep's clothing would be found to be constitutional as well. All right. So Jack Miller and Frank Layton have been indicted on this violation of the National Firearms Act. At the trial level, they argued to the trial court, purportedly they argued to the trial court, that the NFA, being a tax law in sheep's clothing, was unconstitutional. And the trial court, who supported the NFA, pretended to agree with them, squashed their indictment purely so the issue could then be appealed up to the U.S. Supreme Court, and the U.S. Supreme Court could reverse him and issue legal precedent, appellate case law, that found the NFA did not violate the U.S. Constitution. So the trial court, continuing now with the opinion, the trial court held that Section 11 of the National Firearms Act violates the Second Amendment. It accordingly sustained the squashing of the indictment. The case is here by direct appeal, so it went straight to the Supreme Court. Considering Sunzinski versus United States from 2 years earlier, decision from the Supreme Court, and what was ruled in sundry causes arising under the Harrison Narcotics Act, and they list a bunch of cases here, the objection that the National Firearms Act usurps police power reserved to the states is plainly untenable. These tax laws in sheep's clothing have been accepted in other recent U.S. Supreme Court cases. We're going to have to accept it here too. In the absence, the opinion continues, in the absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches in length at this time has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. By the way, why was there an absence of evidence on this issue favorable to Jack Miller and Frank Layton? Because neither they nor any of their lawyers were here to argue this issue, to present evidence on this. So the court's not saying that such evidence doesn't exist. It's saying they weren't shown any. And the only reason they weren't shown any is because the appellants weren't represented in this argument. Continuing now with the decision. Certainly, it is not within judicial notice that this weapon is any part of the ordinary military equipment or that its use could contribute to the common defense. The Constitution, as originally adopted, granted to the Congress power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states, respectively, the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress. With obvious purpose to assure the continuation and render possible the effectiveness of such forces, the declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view, meaning the Second Amendment must be interpreted and applied with that end in view, the militia end. The militia, which the states were expected to maintain and train, is set in contrast with troops which they were forbidden to keep without the consent of Congress. The sentiment of the time strongly disfavored standing armies. The common view was that adequate defense of country and laws could be secured through the militia, civilians primarily, soldiers on occasion. The signification attributed to the term militia appears from the debates in the convention, the history and legislation of colonies and states, and the writings of approved commentators. These show plainly enough that the militia comprised all males physically capable of acting in concert for the common defense. Quote, a body of citizens enrolled for military discipline, close quote. And further, that ordinarily when called for service, these men were expected to appear bearing arms supplied by themselves and of the kind in common use at the time. Blackstone's commentaries point out, quote, that King Alfred first settled a national militia in this kingdom, close quote, and traces the subsequent development and use of such forces. Adam Smith's Wealth of Nations, Book 5, Chapter 1, contains an extended account of the militia. It is there said, quote, men of republican principles have been jealous of a standing army as dangerous to liberty. In a militia, the character of the laborer, artificer, or tradesman predominates over that of the soldier. In a standing army, that of the soldier predominates over every other character. And in this distinction seems to consist the essential difference between those two different species of military force, close quote. The American Colonies in the 17th Century, a book by Osgood, Volume 1, Chapter 13, affirms in reference to the early system of defense in New England, quote, in all the colonies, as in England, the militia system was based on the principle of the assise of arms. This implied the general obligation of all adult male inhabitants to possess arms, and with certain exceptions, to cooperate in the work of defense. The possession of arms also implied the possession of ammunition, and the authorities paid quite as much attention to the latter as to the former. A year later, 1632, it was ordered that any single man who had not furnished himself with arms might be put out to service, and this became a permanent part of the legislation of the colony of Massachusetts, close quote. Also, quote, clauses intended to ensure the possession of arms and ammunition by all who were subject to military service appear in all the important enactments concerning military affairs. Fines were the penalty for delinquency, whether of towns or individuals. According to the usage of the times, the infantry of Massachusetts consisted of pikemen and musketeers. The law, as enacted in 1649 and thereafter, provided that each of the former, pikemen, should be armed with a pike, corselet, headpiece, sword, and knapsack. The musketeer should carry a good fixed musket, not underbasted musket bore, not less than 3 feet 9 inches, nor more than 4 feet 3 inches in length, a priming wire, scourer, and mold, a sword, rest, bandoliers, 1 pound of powder, 20 bullets, and 2 fathoms of match. The law also required that 2/3 of each company should be musketeers. Close quote. The General Court of Massachusetts, January session 1784, provided for the organization and government of the militia. It directed that the train band should, quote, contain all able-bodied men from 16 to 40 years of age, and the alarm list, all other men under 60 years of age. Close quote. Also, quote, that every non-commissioned officer and private soldier of the said militia, not under the control of parents, masters, or guardians, and being of sufficient ability, therefore, in the judgment of the selectmen of the town in which he shall dwell, shall equip himself and be constantly provided with a good firearm. Close quote. By an act passed April 4th, 1786, the New York legislature directed, quote, that every able-bodied male person being a citizen of this state or of any of the United States and residing in this state, except such persons as are hereinafter excepted, and who are of the age of 16 and under the age of 45 years, shall, by the captain or commanding officer of the beat in which such citizens shall reside, within 4 months after the passing of this act, be enrolled in the company, military company, of such beat, that every citizen so enrolled and notified shall, within 3 months thereafter, provide himself at his own expense with a good musket or firelock, a sufficient bayonet and belt, a pouch with a box therein to contain not less than 24 cartridges suited to the bore of his musket or firelock, each cartridge containing a proper quantity of powder and ball, 2 spare flints, a blanket, and a knapsack. Close quote. The General Assembly of Virginia, October 1785, declared, quote, the defense and safety of the Commonwealth depend upon having its citizens properly armed and taught the knowledge of military duty, close quote. It further provided for organization and control of the militia and directed that, quote, all free male persons between the ages of 18 and 50 years, with certain exceptions, shall be enrolled or formed into companies. There shall be a private muster of every company once in 2 months. Close quote. Also that, quote, every officer and soldier shall appear at his respective muster field on the day appointed by 11 o'clock in the forenoon, armed, equipped, and accoutred as follows. Every non-commissioned officer and private with a good clean musket, carrying an ounce ball, and 3 feet 8 inches long in the barrel, with a good bayonet, an iron ramrod well fitted thereto, a cartridge box properly made to contain and secure 20 cartridges fitted to his musket, a good knapsack and canteen, and moreover, each non-commissioned officer and private shall have at every muster 1 pound of good powder and 4 pounds of lead, including 20 blind cartridges, and each sergeant shall have a pair of molds fit to cast balls for their respective companies, to be purchased by the commanding officer out of the moneys arising on delinquencies, provided that the militia of the counties westward of the Blue Ridge and the counties below adjoining thereto shall not be obliged to be armed with muskets, but may have good rifles with proper accoutrements in lieu thereof. And every of the said officers, non-commissioned officers, and privates shall constantly keep the aforesaid arms, accoutrements, and ammunition ready to be produced whenever called for by his commanding officer. If any private shall make it appear to the satisfaction of the court thereafter to be appointed for trying delinquencies under this act, that he is so poor that he cannot purchase the arms herein required, such court shall cause them to be purchased out of the money arising from delinquents. Close quote. Delinquents being people who failed to provide the firearms, ammo, knapsack, all the stuff called for in this act. You'd be fined for not meeting these obligations. And those fines would be collected and could be used to buy guns for people too poor to buy their own. Continuing now with the decision. Most, if not all, of the states have adopted provisions touching the right to keep and bear arms. Differences in the language employed in these have naturally led to somewhat variant conclusions concerning the scope of the right guaranteed, but none of them seem to afford any material support for the challenged ruling of the court below, the trial court that created this test case. In the margin, some of the more important opinions and comments by writers are cited. That is in the footnotes. We are unable to accept the conclusion of the trial court below, and the challenged judgment must be reversed. The indictment goes back into effect because the NFA has not been shown to be unconstitutional. This case will be remanded back to the trial court for further proceedings. Mr. Justice Douglas took no part in the consideration or decision of this cause. That's just one of the 9 Supreme Court justices. He didn't participate in this because he was a new justice, and he had not yet been sworn in when the argument was heard before the Supreme Court. He'd been sworn in by the time this opinion was written, but he didn't hear the arguments as a justice. So he recused himself from this case. So it was an 8-0 Supreme Court decision. Now, if you want to hear about the what happened on remand, the aftermath of all this, what ended up happening to Jack Miller and Frank Layton, all of that is covered in the Law Review article, the 2-part Law Review article that I read in the 2 preceding shows. Again, I'll link to that in the description of today's show. And with that, folks, that is my reading of U.S. v. Miller, United States Supreme Court in 1939, which opened the door for the first time ever to federal regulation of firearms in the United States. Now, of course, the holding of U.S. v. Miller doesn't have hardly ever had any significance, really, except that it opened the door to federal regulation of firearms. And it's since been overcome, of course, by the modern U.S. Supreme Court jurisprudence on the Second Amendment, Heller, McDonald, Caetano, and Bruen, all of which I've already read into different shows. If you go to point your browser to lawofselfdefense.com/2A, the number 2, the letter A, we have an aggregation page there where we've aggregated all of the U.S. Supreme Court decisions on the Second Amendment that I've read into shows in the past, as well as some other Second Amendment content that I've produced. All right, folks, with that out of the way, I will wrap up today's show, except to remind all of you that if you carry a gun so you're hard to kill, carry a knife, carry pepper spray, study jujitsu so you're hard to kill, so your family is hard to kill. That's why I do all those things. So me and my family are hard to kill. Then you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.